Reserved 10 minutes for rebuttal, is that correct? Okay. With that, you may begin when you're prepared to do so.
Good morning, Your Honor, Chief Justice. May it please the court. My name is Ryan Wilson. I'm here representing the petitioners. I'll get first to the matter you asked us to address in that we believe that a quorum is established this afternoon at 3:30, as the parties appear to have reached an agreement on, and that if a new speaker is elected at that point, that there is no more relief that this court could grant for us at that time. The relief we sought was to stop the usurpation of power from Secretary Simon, and Secretary Simon is no longer the presiding officer. There's no longer any relief that this court could grant. This is a case that, I should also say that should that happen, surely it's within this court's power to continue to issue an opinion. We would take really no position on that if the court wanted to lay down the law for future legislatures as to what Article 13 says, but it's not. It will not affect any relief that we're seeking, and so the parties would no longer be seeking an opinion from this court. We would anticipate that we would file a joint dismissal of this case should it proceed as planned at 3:30, and we've spoken with counsel, and they've agreed that to stipulate to a dismissal of the petition again should the agreement proceed as planned. This is a case that unfortunately this court has seen before. It's very similar to this court's case in Palmer v. Perpich. But fortunately, this court's precedent allows it to decide, and has the tools that it can decide this case. And what it boils down to is a plain text analysis of what the Constitution says, of what the Quorum Clause says. Like in 1971, when the Lieutenant Governor there used his power as presiding officer to usurp the power from the Senate, here another member of the executive branch, Secretary Steve Simon, is using his power to usurp the power of the House. Secretary Simon, an executive branch member, presides over the House by statute, not by any constitutional provision, not by election of this House. His role is limited, yet he has used that role to effectively shut down the House. Petitioners Damath and Niska and the rest of the members that are showing up to fulfill their duties have been prevented by Secretary Simon from taking any actions. In his declarations and in his actions, he has not taken any motions from the court or been willing to take any motions, and he has adjourned on his own accord. By denying the members present in the chamber at a lawfully convened meeting of session of the House, Secretary Simon has deprived them of the powers of their office, the powers to adjourn from day to day, and the powers to compel attendance of absent members. His actions are no different than if he had walked to the back of the chamber and locked the door to the chamber, preventing those members from coming in. When Secretary Simon unilaterally adjourns without taking any motions from the floor, he deprives them of the office to which they were elected. I'm happy to answer any questions this court may have. I would reiterate just briefly on the briefs a couple points for the court, and that's in particular, it is the power that's being usurped here by Secretary Simon is power that is granted by the Constitution to the members, the elected members, to show up. Every time that an elected member is not able to bring a motion, any motion, but in particular a motion to compel or a motion to adjourn, they're being deprived, again, of the right of the office that they were elected to. And so this isn't about parliamentary law or whether a particular motion was in order or out of order. It's whether in the first instance that these elected officials have the right to be able to bring any motion, but in particular, again, a motion that's contemplated by the Constitution. And so when that's denied, it certainly is an injury to the entire body, but it's an injury to those individual members too. Like in Palmer v. Perpich, there Palmer was denied his ability to be seated as a member, but this court found that it was an injury both to him and to the entire legislative body. And so they certainly had standing to challenge by what authority the power was being usurped. When we look to the text of the clause, a plain textual analysis lends overwhelmingly in the natural reading that petitioners proffer. to this court. And that's that we have two independent clauses. The first independent clause about what the majority may do, and a second independent clause about what a smaller number may do. And that second independent clause says that a smaller number may adjourn from day to day, which they are not allowed to do, and that smaller number may compel the absence of attendance of absent members in the manner or the penalties that it being the smaller number, may provide.
Counsel, if I can, let me stop you. Two things. One, when you speak again, please speak up. You're a little bit hard to hear.
Okay.
Maybe move the mic towards you. But my substantive question, though, is the Secretary says that if you look at Palmer, basically it says in the absence of a quorum, all the House can do is just meet and adjourn. That's it, and adjourn. And what's your response to that?
Well, as a first matter, they weren't able to adjourn, so to the extent that that is limiting, and if this court's dicta in Palmer, which at issue in that case was not whether a quorum was established, it wasn't the facts before this case. They certainly haven't been able to adjourn on their own accord. It's been Secretary Simon that's been adjourning, but our position is that that was dicta. The quorum issue that's present here was not present there, and that the court didn't need to reach further than it did in that case. And so we don't believe that under that case that this court was making a substantive ruling that the second half of the second clause was a nullity, and that we're making a substantive ruling on that. Rather, it was just not necessary to the holding at that time.
Are you arguing that either of your clients have a particular injury, or are you just relying on the fact that there's an alleged institutional injury?
Well, there's an institutional injury, but each of our clients were injured in an individual injury in the sense that they weren't able to bring a motion or really do any action on the floor when Secretary Simon refused to entertain any motions and gabbled out again without allowing them any of their legislative powers.
So is the inability to bring a motion equivalent to not being seated, which was the injury in Palmer?
Yes, equivalent to being, as I mentioned, to being physically locked out of the chamber. I mean, in essence, blocked from exercising any authority of your office by gabbling in and gabbling out. And there's no recourse after the meeting is adjourned. They're not able to exercise any of the power. So if that adjournment is unlawful, the effect of denying that motion, it's not that the motion itself being denied rises to the level of something justiciable by this court. It's that no motions were allowed because of the manner in which Secretary Simon presided over the office, and in particular, adjourning, on his own accord without taking any motions from the floor.
You can see why it would be a little bit concerning for us to jump into a debate about whether an individual legislature can bring a motion or not on the floor of the House of Representatives. So why shouldn't we worry about, opening that door?
I think the key you said is to bring a motion. The issue here is to bring any motion. It was any and all motion. And understandably, this court doesn't want every time, a motion's out of order or some parliamentary rule isn't followed to have arguments. And of course, the court can deal with that at that time by using its prudential standards and whether it should take that question up and whether it rises to the level of this court. But the issue of standing is that here they were being denied all ability to do anything, whether it be transact business, which they're not allowed to do because it's not a quorum, but the second half of the clause allowing them to adjourn or to really make any motion. Again, they were locked out from completely from their duties, and I think that's different than when issued out before the court, which is that a particular motion being ruled out of order or not being made or someone not being recognized from the floor.
Counsel, if I could follow up on Justice Procaccini's point, I'm interested in your textual analysis of Section 13. In your petition, you allege that by adjourning the House without the assent of the body, without permitting motions or votes, Secretary Simon's usurping power that he plainly does not have. And I'm just wondering where in the Constitution is there a requirement for the Secretary to seek the assent of the body or permit motions or votes?
Well, I think the second clause of quorum clause, and again, this court appears to have reiterated that in Palmer v. Perpich, is that it is the smaller number than a majority, may adjourn from day to day. It doesn't say the presiding officer. It doesn't say the statutorily appointed elected officer, Secretary Simon. And in respondent's brief, they cite to several of the parliamentary practices that it is not in order for a presiding officer to adjourn on their own accord, but it's for the body to adjourn. And I think that's an important power. It's not a matter of just a technicality of ending the meeting, but it goes to when there are important implications into how long session is held open. For example, if the members know that someone is on their way to the legislature, they may be able to establish a quorum if they don't adjourn for another hour. That may be a reason that the body would keep it open. Or if they wanted to reconvene to, for example, 8 a.m. the next day instead of 3:30 the next day, they may be in a different position. So hypothetically, had last night they had adjourned to, let's say, 8 a.m. today, this case would have been moot by now because they would have been able to establish a quorum, elect a new speaker. And so the timing of when adjournment happens, when the reconvening happens, is an important power of the legislature to hold. And so we get that from the Constitution, from that a smaller number may adjourn from day to day.
Does your entire constitutional analysis depend on what the word "it" means in that second part of the quorum clause? Whether that means it as in the smaller number or it as in the House?
Well, if the it, certainly, we believe the textual analysis leaves that it refers to its nearest antecedent of that independent clause, and we think that if it is it, gives us that power. But if that it is read to be something else, I guess the question is it of the House or is it of the majority of each House? And so we don't necessarily lose if the it doesn't refer to a smaller number. If it refers to the majority of each House, well, then clearly it refers to the majority of each House. But if it refers to, and I believe respondents allude to this, just the House, there's a question of, well, the House is convened. We're in session. There is a legal entity of the House. Sometimes it's in a number sufficient to establish a quorum. Sometimes it's in less than a quorum. But the body that's present at a particular lawfully convened meeting of the legislature constitutes the House. There's a case that was cited that I think elucidates this point well. There's an opinion of the justices in Maine that was cited by respondents at 70 Maine 570. The classic bad facts make bad law. In that case, there were two competing legislators, people showing up that didn't have election certificates but were told to by the governor. There was warring with guns. I mean, and so these justices were being called on very short order to be able to answer, who is the lawfully constituted body. And so there's some dicta in there in one part about whether members can be compelled or not. But what's instructive to your question, and this is a long way to get there, is they reference a case 35 Maine 563. And in that case, as to what their powers of the quorum clause are, and in that case, they discussed that they didn't have a quorum for a Senate and at the outset, so before any activity could be done, and their law required that the Senate and the House convene together to be able to elect vacant Senate members. Well, they weren't able to do that because they didn't have a quorum to start in the first place. And the court there discusses, and again, this language appears to be adopted by the latter Maine case, is that if the power to compel after organization is there, surely it must be there in order to get to organization, that they saw no reason in their Constitution why that power would render the Senate useless from being able to form in the first instance if it's able to in the second instance. So on the question is, in their Constitution, they refer to each House in the first clause and each House in the second clause. And so each House alone, again, at least in the Maine Constitution, seems to support that it could support a reading that
Counsel, how does that compare to the language of our Constitution? Because ours reads a little bit differently. I mean, can you make that comparison for me?
Right, so their Constitution reads each House in the first clause and each House at the end of the second clause. Ours reads, the majority of each House, which is different than each House, different than the entire body, and then a smaller number. And so I think it's different in that regard. And then in the it, obviously, it referring back to...
But isn't that important? Because I think what the Secretary is saying is that you have to have, as a part of the organization of the House, you have to have a quorum. And we just said a quorum is 68. You don't have that quorum, and so therefore, at the moment, and so therefore, the members that are there cannot conduct anything, cannot do any business.
Well, they can adjourn from day to day, and we argue that they can compel absent members. And the organization argument, there's nothing again in the text of the Constitution that refers to organization. There's in statutes, the best we can find is that organization is referred to in statute 3.05, titled organization. And in that, every one of those actions have been fulfilled. Members met on that first day, a roll call was done, they presented their certificates, they were sworn in, and that's the end of 3.05, the statute on organization. But again, and so that's to the extent that organization is a line where this court is contemplating whether the compel powers arise before or after. Again, there's nothing in the Constitution that alludes to that, but the statute appears to be fulfilled, and that we are now in, I guess, a post-organization situation.
Counsel, you argue that Article 4, Section 13 empowers a minority of House members to set the rules and penalties for attendance. If that is the case, what would stop a minority of House members from taking advantage of the temporary absence of other members, perhaps members from Greater Minnesota who can't make it to St. Paul because of a snowstorm, for example, or using that power to penalize political rivals in that way?
A quorum would stop them from being able to do that, or a larger majority of a smaller number would stop them from doing that. So any of the penalties that are imposed in the absence of a quorum by a smaller number could be undone, again, once that larger quorum decides to come, or whether it be a snowstorm, whatever it might be that's keeping them from coming. But ultimately, if they're taking advantage of a temporary moment because of a snowstorm so that they could punish their political rivals, it's the people that ultimately look at those actions and say, is that worthy of their reelection? Is that, the people being the final arbiter of whether that was how an elected officer should be behaving? The ultimate check on whether that behavior was okay. But again, in terms of particular actions like fines, deducting pay, these can all be undone by larger majority.
Counsel, your opponents make the point that if your reading of this compel provision, it was correct, a smaller number, a smaller group of the legislators could issue an order or directive to round up absent members and summon them to the House chamber. But they make the point that the officer who would normally be directed to carry out such a directive, the sergeant at arms, can't be chosen until the House is properly organized, which it obviously is not yet. So practically speaking, would that be able to even occur? And does that give us any clue about what the construction of this compel clause should be, how it should be considered?
I think that question goes to what the scope and the means and the manner that the compel clause could be used. There may be practical hurdles to physically compelling absent members to come, but there are other ways to compel the attendance of absent members, such as fines, such as penalty, such as deducting pay, other sorts of things that don't involve having to go out and instruct the sergeant at arms. But again, not before this court, but there are general statutes about sheriffs, for example, that talk about sheriffs can execute any lawful order. And again, this is getting, that's not what's before the court yet. The means haven't been decided, and the reason the means haven't been decided is because Secretary Simon, in his actions, by unilaterally adjourning and shutting down any opportunity to bring motions, didn't allow Representative Niska's motion to be debated, to be heard, to be amended, and to come to a final form. And so it's premature to know what the final contours of any motion to compel would have looked like. Happy to answer any questions, otherwise happy to...
I think we're good, counsel. Thank you. You'll have time for a rebuttal. Mr. Farrell.
May it please the Court. Pete Farrell, Deputy Solicitor General, on behalf of the Secretary of State, Steve Simon. I'll start off by addressing the Chief Justice's question on mootness. Our position is that the petition becomes moot as soon as a speaker is elected, and our understanding is that that will be at 3:30 p.m. today. I do also want to explain the sentence in the filing last night about how we declined to join any joint filing and provide some context around that. We were contacted late yesterday afternoon, and we were told that agreement was likely but not certain, and that they wanted to propose postponing the oral argument. The Secretary isn't part of those negotiations. He has no idea what's happening with them, and obviously the argument was today. So we said, look, if an agreement comes together, we think the appropriate course of action is just to simply dismiss the petition. We'll stipulate to that. I communicated that to counsel again this morning. So, to the extent there's any confusion there, that was what we knew at the time that we became aware of it, and also what we thought was the appropriate course of action, that now that an agreement has been reached, why not just stipulate for dismissal? That said, as to the specific mootness question, when the Speaker is elected this afternoon, we don't see how the petition is not moot, and we have no objection to the court postponing an order until after that happens. So with that out of the way, the court should deny the petition for 3 reasons if it actually proceeds to it. First, the petitioners lack standing. The petitioner's core claim here is that the Secretary is usurping the legislature's power by refusing to hear certain motions. That alleged injury is an institutional one. It is not personal to Representatives Demuth and Niska, and absent a personal and concrete injury, the petitioners have no standing. Second, this petition presents non-justiciable political questions because it turns on core issues of parliamentary procedure. And finally, if the court gets past those threshold jurisdictional obstacles and reaches the merits, Minnesota's Constitution does not allow members to compel attendance before the House is organized and in the absence of a pre-existing law or legislative rule for compelling attendance or imposing penalties against absent members. That conclusion is dictated by the text and structure of the Minnesota Constitution, precedent from this court and other state Supreme Courts, and parliamentary custom and practice, which is best reflected in the advice the Secretary received from nonpartisan House experts. Now, before I delve into those core legal issues, I do want to briefly address just 2 big picture points that are pressed by the petitioners. First, the petitioners throughout their brief and again this morning insist that the Secretary is seeking to usurp the legislature's power and shut down the House. Nothing could be further from the truth. The political parties have put the Secretary in a very difficult position. It is not one he anticipated or asked for. He is doing his best to discharge his responsibilities under the Minnesota Constitution, and he has been transparent in his decision-making throughout this political standoff. Second, the petitioners make a broad public policy point. Pre-organization, doesn't a non-quorum minority need a mechanism to avoid situations like the one we are in now? It is a fair point. This has been a difficult situation. I believe the Chief Justice called it dysfunctional when we were here 2 weeks ago for argument, but there are mechanisms to deal with this situation. The House could, for example, pass a law or standing legislative rule to deal with it. One was, in fact, in place from 1858 to 1894, as we've now discovered in light of the reply brief. But even in the absence of such a law or rule, there is still a mechanism to address this type of pre-organization issue, and that mechanism is political. The 67 who want to be in session can go to the press, rally constituents, and most importantly, negotiate with their fellow legislatures. That solution, in fact, seems to have worked here. What the 67 cannot do is wield substantive power that belongs to the House when the House is not, under the Minnesota Constitution, organized and able to transact business.
Now, Counsel, this is on the justiciability issue. One of the things I have difficulty with respect to your argument is how it differs in any substantive way from the quorum writ of quo warranto that your client brought just 2 weeks ago, asking us to interpret the quorum clause of the Minnesota Constitution. And here we're being asked to interpret just really the second half of that same clause of the Constitution. And if the former was justiciable, why isn't the latter?
So this case is fundamentally different from the last one, and I do understand that it has sort of a surface level appearance of, well, everyone just switched sides because, we were the petitioner last time and the respondent last time. But the cases really are different, and they're different because of this. The Secretary's petition fundamentally just asked the court to basically answer a narrow legal question, like what is a quorum under the Minnesota Constitution? And that was the issue that was teed up by that petition. This petition, the way it's crafted, really asked the court to get into core issues of parliamentary procedure, like what the Secretary should do with respect to certain motions.
I'm not sure well, maybe it's that. It's at least partly that, but it also seems to be, much like in Palmer, what is the authority of the Secretary of State as he is conducting his duties under the statute. And what they're saying is he does not have the authority to prevent the House from following through on the second half of that clause.
So two responses, Chief Justice. One is, I do think the way they've put the issue before the court does require the court to wade into parliamentary procedures that courts typically don't get into. Now, maybe there was a way to craft a petition so it will be different, but I would draw an analogy to how the court addressed a similar constitutional crisis in the Dayton case from 2017. That was a case where the court reached one core constitutional issue, which was, were the governor's line item vetoes under Article 4, Section 23 in that case constitutional? The court did resolve that question. But there was a secondary constitutional question in Dayton, and that was whether the governor's use of the line item veto power violated the separation of powers. And the court declined to reach that question, invoking the political question doctrine, saying that for sound reasons of judicial restraint and respect for coordinate branches of government, that question was one that went too far. And I think that this issue, the secondary issue, this petition that's been brought before the court, it crosses that line. It's a difficult line
This
drawing.
seems like kind of an analogous situation, though, in that, sure, they're making a separation of powers argument, but the core argument that they're making is as to what the second part of Article 4, Section 13 means, the quorum clause. I mean, isn't it almost exactly the same? And isn't the issue that was addressed in that case similar to what they're really asking us to address here?
So I think the court has to read that into the petition, and we defend and deal with a lot of declaratory judgment actions challenging, executive action is unconstitutional or statutes is unconstitutional. Usually there's some sort of statement in the petition or the complaint that says, declare that the Constitution means X or say that the statute is unconstitutional. Their petition, if you look at paragraphs 33 through 35, is just teed up in a different way. So I do think it's different. But just to get to I think the heart of your question, it's, these types of disputes do always raise difficult line drawing problems, and this petition, we think, just falls on the wrong side of the political question line.
Who would have standing?
So I think
the body doesn't exist, if you're going to say the body.
The body doesn't exist. That is one possibility. I think the person, if someone had standing, it would look a lot more like Palmer. Now, Palmer...
In this case, then, because Palmer was unseated. It's a different...
Right,
I get that. So maybe no one has standing in this case. That's kind of the conclusion I would draw from your arguments.
It's possible that no one has standing. That does happen sometimes.
So a Secretary of State, whether Steve Simon is usurping power or not, setting that aside, but some constitutional officer could do that, and some Secretary of State in this context, and no one could fix it. How can that be the answer?
So I would look at the facts of Palmer if the court's really concerned about that, because Palmer, the plaintiffs in that case, as we understand it was Palmer who was denied a certificate of election, and George Goodwin, that was the other petitioner, he was denied an officer position as the Secretary of State. That's who the conservative faction wanted seated. Those are both injuries that are personal and ran to them. Right. So
I understand that.
Right.
So in Palmer, there can be standing. But in what Steve Simon is alleged to be doing here, no one would have standing, and it couldn't get fixed. I mean, I think that you can't just say, well, look at Palmer, because you're saying Palmer's different.
Right. Well, I mean, I think you could imagine an officer challenging, well, I don't want to invite more litigation against the Secretary, but I think you could imagine an analogous situation to Palmer where an officer would challenge his actions as usurping legislative power, similar to what's been alleged here.
What officer?
Someone who has been denied, for example...
Like being elected speaker?
No, chief clerk, I think would be...
Oh, you think that... Why would it...
So,
how is the chief clerk any different than the Speaker of the House in this context?
Well, I think because there are different rules around legislative standing, and that's well established in Supreme Court precedent that individual legislators do not have standing if they are alleging an injury that is institutional, that is not personal or concrete and does not run.
And there's also no chief clerk, right? I mean, so how could the chief clerk that doesn't exist have standing?
I think the theory would be that that person was being denied a job, more like Palmer. But again, there very well could be no one who has standing to challenge this, and we acknowledge that. That's
If there were 68 legislators and the secretary adjourned without allowing motions or an election of a speaker, would your argument be the same?
I'm sorry, Justice Procaccini, could you repeat that?
If you had 68 representatives instead of 67, and the speaker took all the same actions that he's been taking, who would have standing to challenge that action? In other words, can a speaker just not allow...
Secretary.
I'm sorry, the secretary. Could the secretary take all those same actions even if there were a quorum? And would anybody have standing to oppose that action?
That would be fundamentally different in my mind, because in that situation, the speaker's statutory authority only runs until a speaker is selected.
What if he just adjourned the session?
If he just
And
adjourned the
who would have
session.
standing to challenge that?
In that situation, well, that case I think would just be fundamentally different from this one, but we would just have to see what the petition said. I don't see a personal or concrete injury there, so under legislator standing rules, there might be a situation.
I mean, the argument gets you into a pretty tricky spot where you could imagine a rogue secretary really abusing that power and not allowing formation of a House of Representatives, even if you had a quorum, right?
Right, so let me just make one more point on this, and then if I can, just pivot to the merits. I think there generally is a presumption of good faith and regularity when it comes to government officers, so I don't think you have to assume the rogue Secretary of State. That is certainly not what you have here. I think you can assume a secretary who's acting in good faith, so I think that situation is very, very unlikely to ever arise. And under prevailing precedent, it's under legislative standing rules, we just think this is a bridge too far.
Counsel, before you go to the merits, though, still on the standing, why doesn't Representative Niska have standing? In his affidavit, he claims he's tried to make many motions to get this issue on the floor. That's personal to him, it seems to me, isn't it?
I disagree, Chief Justice. I would look at it the same way the U.S. Supreme Court did in Raines, where one way to sort of suss out whether an injury is personal or institutional is to ask whether the claim would exist if the member retired tomorrow. If Representative Niska decided to hang it up and wasn't a member of the legislature anymore, he wouldn't have a claim. That suggests that it's an injury that runs to the institution, not to any individual member. And here, of course, there's nothing special about Representative Niska. The Secretary was not hearing motions from anyone. And so we think that makes the injury alleged institutional. Turning to the merits of the Article 4, Section 13 issue, the Secretary's view is that the most natural reading of that provision is that it presupposes an organized House or some sort of pre-existing statute or rule.
Can you talk, counsel, specifically as you're talking about this, about why can't the word "it" in Article 4, Section 13 refer to a smaller number of members present?
Sure. So if I may, Justice Hennessy, I'm going to get into the grammar weeds for a second, and then if I could come back out and make a broader point about the language. So in terms of their grammar argument, I just think it's wrong. They talk about like the nearest antecedent. A smaller number there is not functioning as the subject of the second clause. It's really an incomplete prepositional phrase. It's a smaller number of the members of each house. And as and when you sort of plug in and I think that's right. And if you plug in that the members of each house, it's clear that that language is actually functioning as a phrasal adjective. And so adjectives don't take verbs. It is referring to the true grammatical subject of the sentence, which is house. So we think that is the proper way to parse just sort of the hypertextual reading that they're offering, and ours is the better one. But even just taking a step back, because the Minnesota Constitution, I think, is not a document where that type of hypertextualism gets you so far, I would look more generally at how the document talks about it versus they and treats entities versus office holders. So there are examples throughout the Constitution in Article 4, Sections 10 and 11, where they are talking about members or elected officials, and they use they. When they're referring to the entity, the House, they refer to it. Similar in Article 6, Section 7, when the Constitution talks about court as opposed to judges. When they talk about court, it says it. When they talk about judges, they say they. And so we think those textual clues all lend support to our interpretation that it refers to each house. And in fact, the historical evidence that's been developed in this case supports that, because they cite in their reply brief an 1858 law, and that is a law that we have since confirmed. We first became aware of it in the reply brief. It was repealed as part of the 1894 statutory revision, so it is no longer on the books. And with the court's permission, I'm happy to file a supplemental letter that would...
Counsel, if I could stop you, that was a helpful explanation, but it just seems like you're working so hard to get there in terms of what it means. It seems to me, when you just read it on its face, what you have are two independent clauses. You've got the first clause, a majority of each house constitutes a quorum to transact business. That's the first clause. And there's a comma, then there's a second clause. But a smaller number may adjourn, till you get to the end, under the penalties it may provide. It just seems to me that the it refers to the subject of the independent clause, and that's the smaller number. Why isn't that just the easiest way to read it? That just seems to make logical sense.
So let me get out of Louise and try to make a couple big picture points about why I don't think that's the best way to read it. And that's just some of the practical concerns that we raise in our brief, which is that it is better and consistent with the U.S. Constitution if you just read it to refer to each house. And the reason for that is, if you adopt their reading, it really does create the opportunity, as Justice Hennessy was alluding to in her colloquy with opposing counsel, for an unchecked minority to really create a lot of mischief. Now, if there is a law that addresses this situation, as there apparently was in 1858, a law that even accounts for what you do for the absence of the sergeant at arms, which is a huge problem here in terms of enforcing this clause, then we think that, the problem's solved. But in the absence of that pre-existing law or rule adopted by the full House as to how the full House wants to punish absent members in this pre-organization posture, then the clause is not self-executing, and it's not self-executing, and the minority cannot act.
Is there anything in the history of this provision that lends any support to the argument that there's this distinction between pre-organization action and post-organization action?
Nothing in the constitutional history that I'm aware of, but within Article 4, we just think inherent in the structure, it assumes organization for most of what the House and the legislature does. And so we just think it's built into the structure of the clause. But there's not specific constitutional history that we've at least been able to locate in the expedited time frame that we've been looking at that speaks to this specific issue.
I mean, isn't there a certain logic to the provision, too, that says, that goes the other way, which is to say a smaller number should be able to bring the rest back so you can get the quorum and start the business of the House?
I think there's some surface level appeal to that, Justice Procaccini, but this isn't an unusual situation in American history. I mean, as they point out in their reply brief, this was a big problem for the first Congress, which has language about compelling absent members. There is the each house language there, so there's that linguistic difference. But that first Congress was left basically sending letters to senators being like, please show up. And so there was no mechanism to enforce it. So this is sort of a very unique circumstance when you have these sort of pre-organization constitutional crises. However, they do exist. And I do think that our reading is not ahistorical. It's consistent with the American constitutional tradition.
Is your reading really that there's kind of three parts to this provision, essentially? That it defines, you have to have a quorum, a smaller number can bring people back, and then the penalties it may provide is kind of a third thing. So the it is about just who develops the penalties. And you're saying the House is the one that has to develop?
No, I think our reading encompasses both is broader than that, because we read it to say,
But then the it, well, okay,
in the manner and under the penalties it may provide, so that we think that links, like we would read that to link sort of the entire power in that clause to the House itself, to some sort of law or rule.
or to the smaller number, depending on how we read that. I mean, I'm just saying you could also read the it as just modifying neither of the first two pieces.
I agree that is another way to read the clause.
Counsel, did you get to finish your thought about the relevance of the 1858 law that was referred to in the reply brief?
If I did, let me just reinforce the point I thought I made or was hoping to make. So with respect to the 1858 law, we think it really reinforces the reading that we put forward in our affirmative brief, because it shows that the framers of the Constitution actually understood that the compel power in Article 4, Section 13 was not self-executing, that they understood that they needed to account for the situation that we find ourselves in now, which pre-organization, before commencement, what do you do with absent members? There's no sergeant at arms to go get them, for example. That's one thing. So we think that history, that law does show that our reading of the constitutional clause is the better reading.
I can't remember, is the sergeant at arms listed in the Constitution?
I'm not sure, Justice Heason. I don't believe so. But that is something I don't know standing off the top of my head.
Counsel, you in your brief alluded to the possibility of a more developed factual record being necessary for the court to really consider some of these matters, and I guess I'm wondering what facts you would think could be revealed that we aren't already privy to that are discussed in the declarations here.
So the facts that I think would be developed in the district court are really they're legal facts, the legal and historical record. And those facts are relevant, particularly in constitutional litigation, and I would point to this court's decision in Rice versus Connolly, where it explained why, even though the court would retain original jurisdiction in quo rento cases, it would only exercise that jurisdiction in very rare cases. And that decision described a little bit about what the parties did on remand, and there weren't many disputed facts in that case. The facts were largely stipulated to. But what the parties did was brief and developed the record around legislative history, constitutional history, all those things that you expect to see when a case typically comes to you. And that record development is really important. And if I may just draw an analogy, our office is litigating a lot of Second Amendment cases right now. In those cases, a lot of times the facts are not disputed in any way. Like someone who is 18 wants to buy a gun, or this person was convicted of X. But there's still quite a bit of record development that has to go on at the district court level about sort of the history of, the history around gun restrictions and what different analogies are. And so that record development is typically really helpful to appellate courts. And so this case, especially now that I think the exigency has been taken out of it, one appropriate disposition here would be just to dismiss it without prejudice and say, you're free to, Representatives Damath and Niska, you're free to refile in Ramsey County District Court if something goes haywire today. But we just want to reiterate that we are only going to exercise our quo rento jurisdiction in those most extraordinary circumstances. And the court has, even in really big cases, declined to exercise its quo rento jurisdiction. Limmer versus Swanson, the first big budget stalemate case, is a good example of that.
Counsel, if I could just back up one step and just ask a couple policy kinds of questions. If we adopted your sort of beginning of the session exception that you're talking about, your opponents say, well, that would allow some legislators then to effectively prevent the House from ever meeting during the entire session.
So
that's not a good thing. So what are your thoughts about that?
So Two responses, and it will echo some of what I said at the outset, which is, one, the House, the legislature could come up with a way to deal with this situation once the House is properly functioning, and apparently at one time did. There's no pre-existing law or rule to deal with this situation, and so in that vacuum, the compel clause is not self-executing, but it is one that the legislature could solve, and maybe they'll take a hard look at it this session. Second, even in the absence of a legal compulsion power, there is a mechanism to deal with that, and that is the political process. And that's exactly what happened here. There was a standoff, there was negotiation, and now there's an agreement, and the legislature is going to come back into session. So even if there's not a constitutional mechanism for the smaller number to compel the attendance of their absent members at the outset of the session, there are other means for them to pursue that relief.
Thank you, counsel. Your time has expired. Mr. Wilson, you now have rebuttal for 10 minutes.
I think that's an important point we sort of touch on at the end there, is whether this is self-executing or not, or whether it needs some kind of enabling legislation. And what I heard from my friend on the other side is that there was no statute passed or no House rules passed. Well, there couldn't have been. One legislature cannot bind the next legislature. So even if rules had been passed, those rules would not have allowed whatever was being assembled here to be able to compel.
A statute would, though.
It's unclear if a statute could, the House gets to decide its own rules, and it's unclear if a statute.
No, if they passed a statute about how they were going to operate, that would be in existence and bind a future legislature until that future legislature repealed that statute, right?
True, but that statute couldn't constrain powers given to the legislature that are inherent to their authority. So if they have the right to be able to compel, it couldn't take away that right to be able to compel. That would be a previous House.
Well, maybe it would be an unconstitutional statute under your reading of the statute, but so the legislature can't pass a statute to, well, what about 645? I guess that's binding us, not them. So they can't pass a statute that binds themselves.
Correct. I think it's axiomatic that one House cannot bind the next House. That House has, each House has a right to set its own rules, to elect its own presiding officers, and they couldn't entrench the next legislature to be able to say this has to be your speaker, for example, for the next 2 years. They can certainly provide, like that statute in 1850 or 1858, they can provide direction, whether it be a directory statute. They can provide means for carrying it out. For example, they could say that when the legislature chooses to compel, the executive has to take these steps. But one House cannot bind, the next House, and certainly cannot bind it to the extent that it takes away constitutional power.
How far does that argument go? You're saying that the legislature can't pass laws telling branches of government how to execute their constitutional duties? That would be a pretty radical step, I think. I think the legislature does that all the time for us and for the legislature. And for the executive branch, right?
Oh, I think this was raised in the last litigation we had here, but the House, the House and the Senate, the governor passed a statute regarding access to Minnesota governmental data, and this court said it was within this court's inherent authority to be able to decide its own records and who has access to it.
But this is not a separation of powers issue. This is a legislature binding. It's like, what about 3.084, lobbying activities prohibited? It prohibits lobbying activities at certain times. That goes away every legislative session?
No, they don't have a constitutional right to be able to lobby here. They have a constitutional right to be able to compel the attendance.
And that's why I'm saying
yes.
that statute would be unconstitutional.
Correct,
That's really
yes.
the argument.
Yeah.
Okay.
Correct, Your Honor, yes.
If a statute said they couldn't compel, but if a statute said here is how you compel, why couldn't the legislature pass a law saying this is how you execute your constitutional power? And why wouldn't that be binding on everybody?
I mean, to the extent it narrows, power, a broader set of power that the Constitution granted the legislature to something narrower, that would create potential problems in that it took away power that the Constitution had inherited explicitly.
I think we should just kind of move on from this argument.
One of the things that came up was the first Congress, and I think my friend here said, well, all they did is they showed up and they were able to send letters. Well, it's something that perhaps this Congress, or perhaps this House would like to be able to do, is to show up and to issue letters. They're not able to do that. They are completely foreclosed from taking any action. The 90th legislature versus Dayton, 99th legislature versus Dayton was cited to as an example of where there were certain limits to where this court was going to entrench on, that the political nature of things could resolve themselves. But in doing that, it said that the legislature hadn't been completely defunded, that had been completely, in essence, absolved. Here, we have that fact pattern. We have that there is no, whether it be transacting business, compelling, adjourning, there is nothing that through Secretary Simon's actions that the House is able to do. And so, for that similar reason, this is justiciable.
Can I just ask you about the constitutional history, I guess? So, as I understand it, both the Democratic body and the Republican body at the time of the Constitution had each body where it exists today in this provision, and they passed them out. They passed it out of each body, and then it went to conference committee, and that the body or each body was changed to it in conference committee. How do you read the implication of that? Do you understand what I'm asking?
Right. And there's not to the extent that there were ample records of the debates in the individual convening, when they came together and convened, there's not a good record of why they made these changes. We, of course, would say that there's meaning in that they looked at what was happening, around. And so, again, I would urge this court to look at 35 Main 563, and I was able to get the exact site, at 597 to 598. This case regarding the power to compel when there was less than a quorum happened 4 years before our Constitution and our state came into it. So this would have been theoretically on the mind of the people framing it. And there's just no reason, when you take a step back to the structure and text of the Constitution, as we argue in our brief, that why organization would be a magic dividing line when something we have no interest, the state has no interest in forming a legislature, when people don't want to show up before the first day, but sometime during the legislature they do want to show up. The Constitution grants things like freedom from arrest on the way to the legislature and while you're on the floor. And that's an incredible power. And so I think the entire structure of the Constitution wants to form a body, wants to legislate, and Justice Hudson, Chief Justice Hudson, you had mentioned when asking about their position why it should be at the beginning of session. Well, that's not what they're not arguing at the beginning of session. Session happened January 14th. We agreed that there is a legal session that is happening. That was one of the issues in the Nebraska case that they cited. There, the issue wasn't a legal session. It was called by somebody that didn't have the authority to call a session, and then things that happened during that session. Well, here we are in legal session. The issue is, and we have a House that is attending. A House is adjourning every day. What we don't have is a quorum of the House to be able to transact business. But the House certainly has arisen on that first day under 3.05, where members came, presented their election certificates. They moved from members-elect to members. There are journal entries being made, and so the House is in existence. Session has started, and the argument is there some kind of other arbitrary organizational line that these powers come into effect? A couple of things I wanted to touch on.
Why isn't political accountability enough here? We heard that argument from the other side that these sorts of disputes will work themselves out through the political process, as they apparently have done over the past 24 hours. Why isn't that enough, and why do we need to jump into the fray here?
Well, I think for the same reasons that this court jumped into the fray in Simon v. Damuth, certainly time and enough, public pressure and political pressure and accountability in the next election cycle could resolve some of these issues. But in the meantime, the people are without a functioning legislature, and I think this court, has the duty to say, has the ability to say what the law is, and it's a core function, Marbury v. Madison, of what this court does. And I think interpreting the second half of the quorum clause is important for Minnesotans and for the legislators to know the rules by which they're operating, and it's important. To that point, with the political part, what I heard was, again, from my friends on the other side, is that Perpich is distinguishable because a member potentially, that member had standing because he was being denied a particular right. So had Perpich shut down the entire legislature, then his actions would have been okay, or would have been not justiciable by this court. I mean, that's what I'm hearing. So he didn't go far enough in how much power he usurped, and clearly that can't be the line that is drawn. Some is made about legislative standing. I think legislative standing is more has to do with once a bill is enacted, the right for a legislator to be able to challenge, how it's being implemented, whether it's being implemented in the way that it was supposed to be, whether it's undermining. I just don't think those facts apply, or that law applies to this core warrant or petition where we're asking about what power was Secretary Simon usurping, from from the legislative body. And I think, again, throughout the briefs and what we heard today, I haven't seen any argument offered by the respondents as to why Secretary Simon has the right to unilaterally adjourn. Surely the Mason's Manuals, which is a treatise, it's not binding law, but it's a treatise on how a presiding officer is to preside. So he's not to take must take a motion from the floor and cannot unilaterally adjourn. And again, I've seen no argument to that. And so we believe this court should reach both questions, whether Secretary Simon can adjourn unilaterally and to the extent to which the compel powers apply to a smaller number. But again, we've seen no argument raised as to why adjournment should be the sole duty of the Secretary. And again, there are strategic reasons why, important reasons why, to help form a quorum, one might want to keep open the session longer or reconvene at a different time. Again, I go back to, there was a comment made that there's nothing particular or special about Representative Niska. I think that goes back to if the usurpation is broad enough to foreclose standing from anybody, as opposed to just foreclosing Representative Niska from being a motion. I don't think that argument stands. And again, getting back to session, the term here we had an interesting occasion. We talked about this in the special election case, which is that there was a gap here between when the terms start of each member's and when the session starts. So there's really three things at play: that the terms have started, the session then started, it commenced on the 14th of January, and the House is in session, and the session is limited. It's going to end at a certain time. And so every day that they're not able to use those compel powers are days that they're not able to get back into being able to legislate, to transact business, to do the will of the people. So I see I'm out of time. Thank you. Thank you, Your Honors.
Thank you very much to all counsel for the help that you provided the court here today. We will take the matter under consideration and issue our opinion in due course. We are adjourned.